I'll get on to introductions. Today on our panel, we have from the Early Defense Practice at the Bronx Defenders Family Defense Practice, its director, George Kotis, and a supervising parent advocate, Jean Padilla. I think he's logging on if he hasn't logged on yet. He's not showing up in my screen, but I have like 6 screens over here. So as I have to flip over. Okay, great. Thank you, Jean. From our office, the Monroe County Public Defender's Office, we have Special Assistant Public Defender Robert Turner and Senior Caseworker Tonisha Anderson from our Family Defense Project. From the previously mentioned ILS, we have Lucy McCarthy, the Director of the Family Court Representation Team there, and our moderator, also from ILS, Carolyn Walther, the Family Court Representation Appellate Attorney. So please join me in welcoming our panel. I am looking forward to a very robust discussion today. And to start, I am going to pass this off to Lucy McCarthy. Thank you, Lucy.
Thank you, June, very much. Good afternoon, everybody. Thank you so much for signing up and attending this CLE. I'm so pleased to be here with you. I'm hoping that the outreach about this program that was conducted by the point people who are actually part of this, who are online with you right now, Kevin Roman in Western New York, Kira Scatino in the Central New York region, Michelle Hutchins-Weinholz for the Capital District and North, and our statewide community outreach expert, Diane Wynn, was effective, and that many of our new grantee counties have joined us today. My part of this event should be relatively limited because I need to yield time to the experts who will share with you the practicalities and successes of effective investigation representation. Theirs is the experience that will better inform you about the barriers you may expect in terms of implementing a similar program, what client consults really look like, and what supports and resources parents really need and actually need to avoid court altogether. What I can provide is the exciting context of where we are today in terms of where investigation representation is or will be available in New York, and our work, ILS's work to promote timely access to counsel that allows parents to make decisions that are right for their families. Investigation representation provides legal advice and support, obviously, when parents need it, instead of days, weeks, or months after a Child Protective Services investigation has had a profound impact on each family. You need only ask yourself when you would prefer the advice and counsel of an attorney and the support from someone who is system informed if you were confronted by a government investigator who is asking questions about your parenting and your home to understand why this representation matters for parents who cannot afford a private attorney. Today, for this audience, you'll likely know that ILS is charged with studying and making efforts to improve the quality of public defense, including family court, of course. One of the ways that we do this is by observing effective models and providing grant funding to support the development of best practices that have the most impact for clients and outcomes. As you know, for a number of years now, New York City providers have offered specialized teams of attorneys, social workers, and parent advocates to provide this advice and support as soon as possible during a CPS investigation, with profound results, including reducing system involvement and the number of petitions filed, as well as connecting families to resources that will prevent future system engagement. You will hear from one of the New York City offices who have vast experience with this model today. Our ILS competitive model office grants were crafted to demonstrate that this model of representation is just as necessary and effective upstate. You'll also hear from one of the model offices today, Monroe County Public Defender's Office. They joined Westchester some number of years ago now, where the model office is hosted by Legal Services of the Hudson Valley as a model office. This year, we are thrilled to announce that, and have announced that they will be joined by 4 new model office counties: Orange, Schenectady, Onondaga, and Chautauqua. In addition to the competitive model office grants, several years ago, ILS was also able to offer more modest competitive grants to counties. The quality initiative menu that counties selected from included one or more of the following: caseload relief, adding resources for interdisciplinary representation to include social workers and parent advocates as part of the team, adding resources for access to experts, And notably for today, timely access to counsel, meaning investigation, representation, and finally the last menu option was training. We received lots of creative and innovative proposals from the counties for their family court public defenders. Notably, many counties opted to provide timely access to counsel, meaning investigation representation. And last year, as a result of the allocation afforded in the ILS budget, we were finally able to offer a baseline grant on a non-competitive basis to the remaining 15 counties that had not yet secured ILS family court grant funding. I'm going to share my screen now, make sure I do it correctly.
Thank you.
Okay. We're still finalizing some contracts. Can you see the map okay? Yep, thank you. We're still finalizing some contracts with some counties, so the reality could change. And we're not adverse to a contract modification if the county wants to dedicate otherwise unspent funds to investigation representation. But the choice to offer investigation representation remains a priority for the counties and providers. Let me show you exactly what this looks like. You can see on the map that we have a representation for the counties that offer whole county investigation representation, meaning all of the family court public defenders are offering investigation during a CPS investigation or offering representation during a CPS investigation. And then we have some counties where it's being offered by at least one provider, if not more, but it can't be thought of as a whole county. There are only a few counties that are not receiving any ILS grants to support investigation representation. We're not stopping them from offering investigation representation, but we're not able to support that at this time. There are at least 30 that are doing investigation representation and at least 19 where the whole county is involved in investigation representation community outreach, or they want to or will be soon. On the next page of this document, which we'll supply after the training today, we've also provided a list of the providers who will be offering investigation representation so that you can connect with them and strategize implementation that makes sense for your community. We encourage you to reach out to each of us and each other to share what works for your community outreach, what works for covering conflicts, and the results that you will see when you are fully up and running, providing investigation representation. This is an exciting time for investigation representation, even though I've been part of the grant process at ILS for years. When Di prepared this map and list for this presentation today, thank you very much, Di. And I reviewed it. I actually had to sit back for a moment to absorb the progress that has been made. But truly the progress should be attributed to the tireless dedication and effort from the public defenders themselves who have assumed new responsibilities with purpose and energy. So now I will actually turn it over to Carolyn so she can ask questions of the panel so you'll learn from them and go better prepared to implement your own programs and work towards statewide implementation someday.
All right. Thank you, Lucy. That was great, very informative. And, Lucy used the word exciting a couple of times, and I couldn't agree more. I really think that getting involved in a case early can just have such a tremendous impact on the family and how things move forward in the process. And so I won't talk too much about that. I'm going to let the people actually doing the work talk about that. And so the first question that I have for the panel, and I think for this one, we'll start with George, if you're okay taking the lead on this one, just to talk about the structure of your program. So how many staff members you have, what are their roles, how do you fit into kind of the overall structure of your office? Also, are you doing court representation as well, or are you only doing investigation representation? And if you are doing court representation, is that just Article 10, or are you doing other cases too? Robert and Tonisha, you will be up next. You're not off the hook, but we'll start with George, and Jean also feel free to chime in.
Thanks all. Again, my name is George Codis, he, him pronouns. I'm the director of our early defense practice at Bronx Defenders. We actually very excitingly have a bigger team than we did until recently. We're about 9 to 10 people, and I say 9 to 10, I'll describe. I'm the director of our early defense practice. We also have a supervising attorney. We have 2 staff attorneys. And then we have a supervising parent advocate, that's Jean, who's with me today. And we have 4 staff parent advocates. And then the reason I say 9 to 10 is because our 10th person, we also have an administrative staff, we call it a legal assistant, who works with other folks in the office, but she also specializes and supports us as a team. But again, like I said, that's a recent development. The kind of brief timeline is we've had a family defense practice that does represent parents in Article 10 proceedings since 2008. Before that, it was kind of like a pilot project, but 2008 is when New York City asked for requests for proposals and began institutional representation of parents. So our practice has been around since 2008, and it was about 10 years. It was 2018 when we realized and first hired our first designated early defense or investigate. So and any investigation phase, pre-petition phase, we call early defense. That's our terminology. So our first designated early defense advocate was hired in 2018, closely followed the next year, 2019, by having a designated attorney assigned to that. And then from 2019 till last year, it was that amazing team of 3, including Jean, holding it down. And it was though last year that the office made the big, bold move to expand, created my role, be an actual director of the practice, and expanding it to include more attorneys. As we push and get more funding from the city, from ILS, we were able to figure out that we could, in fact, have a team of this size. And so, as I noted, we do also represent parents in Article 10. That's actually how we started as a practice. Our early defense practice is essentially housed within the broader family defense practice. For the moment, we're integrated to the extent that we work with each other, but our then regular FDP, family defense practice attorneys, will handle any cases filed in family court. However, the plan, the hope, and I swear we're like kind of in spitting distance of starting to do this, is we want to have our attorneys who actually handle the early defense, the investigation phase, be the assigned attorney if unfortunately ACS, our CPS here in New York, chooses to file in family court. And so that, something what folks call vertical representation. So we hope to have that. One of the reasons we hadn't had it until now is because, like I said before, it was just a single attorney for several years. But even now, the 2 staff attorneys we have on board, and our supervising attorney for that matter, were pooled from our existing staff. We actually posted with the requirement that they have about 2 years experience in Article 10 cases. I'm not suggesting that needs to be a requirement for that role, but that's how we decided to do it because we felt like that could help with the advice they give to clients that are in the investigation phase. But for that reason, our attorneys that we onboarded last year had very full caseloads in Bronx family court. So we couldn't then have them take on every case that comes to early defense. But slowly we've been kind of, whether by closing out cases or transferring cases, and by keeping them off as many shifts in family court, we're reaching that sweet point, that kind of point where the sweet spot where I think they'll be able to start just taking those cases and handling them. So, and then we do mainly focus on Article 10. We have a contract with the city that assigns us to those cases. We will, in fact, participate and represent parents on custody, visitation, family defense, CVO dockets, but that really is only if they arise during the pendency of an Article 10 case. So we won't get assigned. We're not on a panel that gets assigned on CVO cases. However, if in the course of an Article 10 case, CVO cases arise, and then, as is usually the case and by the statute, they then get litigated once the Article 10 disposition is completing, or at least for custody visitation, we will remain on the case for those.
Okay.
And just to add a little bit to that, in terms of like the parent advocate's role in the cases, when hypothetically speaking, like let's say the parent advocates are working with the family throughout the 60-day investigation, and then towards the end of it, ACS decides that they are going to file. If this is a case where we're asking for like a 1027 or a 1028, the early defense parent advocate that was working with the parent throughout the entire investigation will stay on the case for the pendency of the 1027 or 1028 until, whether we win or lose, but they will be highly involved in that process. And then once the 1027 or 1028 concludes, they then close out, and then they'll defer to a parent advocate or social worker on the attorney's team that
And
was assigned that intake.
That's great. So if it's a case where there isn't a 1027 or 1028 hearing at the outset, would you hand that case off then right away when it gets filed in court?
Yeah, so our parent advocates do a warm handoff where they would meet. If the client is coming in person, they will go with the client in court, introduce them to the new attorney that's going to be taken over, be there for the initial court appearance, and then from there on out, they'll close out. And then if the attorney deems that a parent advocate or social worker is necessary in the case, they can refer to their referring social worker or parent advocate. But we'll
Gotcha.
do like the very early stages.
Okay, gotcha. I love that term, warm handoff. All right, so Robert, putting you on the spot, would you be able to talk about the structure of your program? So how many people, what are their roles? What types of cases are you handling court cases, or is it just investigation?
Sure. First of all, my window's open. If there's noise in the background, please let me know and I'll close it.
I don't hear
Everyone can hear?
anything.
And everyone can hear me well enough?
Yep.
All right, good. Yeah, so here at the Monroe County Public Defender's Office, until we received the grant from ILS to form our Family Defense Unit, we were just one family court bureau, just attorneys, one secretary, one paralegal, and the attorneys did everything, Article 6, Article 8, Article 10, as well as child support violations and other ancillary matters. But with the grant, we were able to form our own distinct unit, the Family Defense Unit. And currently we have 3 attorneys, 3 social workers, a parent advocate, and we also have a paralegal who works with us as well. So that's our team. And we do now early defense work as well as in-court work. So we maintain our in-court work, our Article 10 filings, which come in pretty regularly, as well as now the early defense / pre-petition / investigation representation cases. So that's been the new part, and also having the interdisciplinary team with the social workers and the parent advocate in particular. So we've been pretty busy. We're getting referrals from the community. We get referrals from the criminal defense side of the office. And we also get referrals from CPS. They obviously cherry pick what they send us. So we don't want to be overly reliant on them. We want to go directly to the community. So we're intensifying those efforts. And the investigation representation cases are very social work parent advocate intensive. That's the attorney's job, is to give the client advice on, the potential consequences of what could happen depending on the direction of the case. Either it'll be closed, unfounded, or indicated and closed, or if there is a court filing, then we transition to the in-court part. But in terms of the, rolling up the sleeves, it's really the social workers and the parent advocate who are doing the bulk of that work. So I'll just let Tanisha just describe some of what that's been like.
Yes, so we're on a rotation amongst ourselves and our social workers, and as well as assistant from parent advocate when it comes to early defense cases. A lot of times when I receive the initial intake and I contact the parent, they're in panic. They're nervous. Their immediate response is, "Oh my God, CPS is going to take my kids and help me. And it's like, no problem, I'm there. A lot of the nervousness that I'm experiencing is that the parents do not feel comfortable being alone with the CPS investigators. A lot of times it feels as if there's a lot of tension between the investigator and the parents, and that makes it difficult for
Tanisha, can you hear us?
the investigation.
I think she's breaking up.
There is questioning the children, whether it's alleged in the report.
Sorry about that, folks.
Tanisha, can you hear us?
Yes.
Okay, all right, you're back. Sorry, we lost you for a minute. Sorry.
Sorry. No,
I
it's okay.
you were talking about how a parent doesn't want to be alone with a CPS investigator just because of the nature of the
Attention.
situation.
Yes. A lot of times that's the main reason why parents do call our office and ask for that assistance. They don't trust the CPS investigation worker. They may have previous experience with that same worker that they feel the worker is being dishonest or being distrustful. So they like a third party to be present. There's been times where I arrived to an investigation and the parent has like a laptop and there's a Zoom and there's other family members there as a witness, just to keep themselves safe and protected for any untruthful statements that may be made. I also feel it's comforting because regardless of what the nature of the report is, no one wants to be accused of doing anything to harm their children. And I feel as if a lot of times that sometimes when investigator initial contact with our parents is negative, because it is a negative interaction, right? A report is made and they're saying, hey, you're alleged to do X, Y, and Z, or you didn't send your kid to school, or you're not giving kids medication, or there's bruises and they said you did X, Y, and Z. It just starts off in a negative. And I feel as if it's even harder to navigate that investigation process when there's just so much tension and accusations being made between, the investigator, and the parent is automatically defensive. They don't want to talk. They don't want them in the house. Well, we have to conclude this investigation. So I really find myself just being making sure that the investigator is asking appropriate questions. I do have experience as a former CPS caseworker, so I'm very well versed as to what's allowed and permitted regarding questions from whatever may be in the report.
All right, great. You guys have done a great job of anticipating my next question, which was going to be sort of who's the point person when a case comes in and how those cases come in. So I did have a follow-up question on that. I think you both mentioned potential clients calling the office. Do you have like a dedicated sort of hotline for investigation cases, or are people just calling the main number and asking for help that way?
The point person is our paralegal, so that's the number everyone is provided. So they're not calling the main office, they're just contacting our paralegal or our designated email address. And then the process is started, the paralegal follows up, gets the information from the person, does the conflict check, and then presents it to me as the supervisor as whether it's a case that would be eligible for our program or not. So a lot of people are calling just because CPS has been involved in their life, but there may not be a current investigation. So our flyer that we disseminate around the county says, are you being investigated by CPS right now? To help people focus on right now. And that's where we want to catch them as early in the process as possible.
Mm-hmm. And Robert, I did have one more follow-up question for you,
Sure.
Which is that you mentioned CPS sort of cherry picking cases that they send to you. What types of cases are they selecting to send to you? Do they have something in common?
Well, they do send us a lot of educational neglect cases, which sometimes, especially when you're dealing with older children, can be very difficult, depending on the family dynamic, what's going on with the child or children, what their past trauma is, what are the barriers with respect to school. So we do get a lot of those. And, sometimes they treat us like a preventive agency. That's sort of the tension we have in terms of what they send us. They're sending us cases that they could refer to other agencies that actually do preventive work, or they've tried other agencies that have done preventive work and it didn't work out. So they're coming to us as a last resort, but still in the context of a preventive type of agency. So we try and explain to them what our purpose is. So I haven't met recently, but I try to meet with our counterparts in the Children's Services Agency department of the county law office to explain to them what we're looking for, and that's an ongoing process.
Mm-hmm. And we will talk more about that a little bit later, thankfully. But yeah, the relationship with CPS, I can imagine, has a lot of different facets to it. So, Jean, I was hoping maybe you could also speak about how a case typically comes to your office.
So at the Bronx Defenders, we have various streams, right? We do have a dedicated hotline that operates 24/7. People from the community can call that hotline at any given time, any given hour of the day. And the way we handle it is that we give like our advocates 24 hours to respond to every call. So that's one way. Another way is that like sometimes we have like our criminal defense, early defense practice as well at our office, but we also have like criminal defense. So whenever there's like an endangering the welfare of a child charge or anything like that, they immediately refer those clients to us, even if there is ACS involvement or not. Just to keep an eye on it, because what if in case ACS does get involved? We also have our community reception space that's open 9 to 5, right? With walk-in hours, people from the community just walk in throughout the day, any given day or any time. And they're letting the reception staff know that there's an open ACS investigation. So we'll have our staff immediately like go to the reception space, meet with the client there, do an intake, and see if we can represent them. But also a huge push that we've had was we've gotten like ACS to give out our flyers, and they created this thing called like a front door notice, where it has like all service providers in the city where they can call and reach out for legal representation. So they have like the Bronx Defenders, Brooklyn Defenders, all organizations in the Bronx. But for us, like we were the ones who really pushed that and like piloted the project with certain zip codes about like ACS giving our notice. I think similar to Robert, right? Like they're cherry picking when they want to give. At first, they were cherry picking in which they wanted to give those out, right? Or choosing when to give it out, right? Like they'll do their initial investigation and be like, oh, here's also like this organization that you can call for legal assistance, after they already tried to gather all the information to use against our clients. But we've gotten better with like, no, that this needs to be the first thing that they're giving our clients or the members of the community. And I think like one last push that we continuously make is like we're getting in like very important spaces. So like George and I and like the whole team does presentations at like shelters, at schools, at hospitals, and informing like all of these mandated reporters of like, hey, like we're not saying don't call in cases, but if you are gonna call in a case, then also like you can reach out to our office, but then also like letting them know the implications of calling in a case. So then now we've built really good relationship with community providers in the Bronx, and they're like directly referring clients to us like, hey, like there's this case where we're trying to teeter whether or not we're going to call it in or not, but can you assist this family with X, Y, and Z? And then we'll just immediately jump in, try to connect the family with the services, and just do what we can to assist. So that those are our various ways of getting clients. George, if I missed anything, feel free to add.
No, I think you got everything, and we also have an email. In addition to the hotline, we have an email that folks can email. Yeah, I mean, I'll echo that. What's interesting is when the practice first started, it's flipped. The numbers have kind of flipped. When it first started, the majority of early defense work was either coming from our criminal defense colleagues who said, hey, there's an endangering the welfare of a child charge in this case, or the ADA mentioned that a child was present in this DV allegation. And so they would refer it, or it was former clients that we'd already represented in past Article 10 cases. And everyone here probably knows there's often a revolving door. And look, here they are with a new ACS investigation. They call their old lawyer. We connect that way. But it has absolutely flipped on its head. And those still come in. We still get plenty of cases that way. But the vast majority of the majority of cases either come from hotline calls, which means they got our number from somewhere, or referrals from the community partners that Jean has referenced. And I think there's two important pieces here, especially as folks, I know a lot of folks on this Zoom or on this Teams are thinking of ways to start out, is that getting ACS to give out our information was huge. We kind of lucked out because that almost, in addition to the front door push, we got this kind of bump during lockdown. when everything was pure, when court was purely virtual, there was a recognition that clients would typically meet their lawyers from our office in court when there was an intake, and that wasn't happening, obviously. So there was an agreement made that, hey, at child safety conferences, we're going to give out, like Jean said, the providers for all 5 boroughs. There'll be a form. If you're in the Bronx, call this number or email this email. That helped get our email out. And the kind of side benefit was that was initially intended like, oh, because they're not coming to court to meet their lawyer, but now they're getting it earlier. They're getting it at the child safety conferences, which is huge. And that's kind of stuck. Every once in a while, we have to push them and say, hey, are you really giving this flyer out? But it's been huge. But then, as Jean noted, the community outreach, I can't overstate how big it's been. I want to push and get even more in schools, education, educational settings, but we've really hit a pretty good saturation point, in particular with one of the major hospitals in the Bronx. I think we've had no fewer than a dozen presentations to various departments of this one hospital, Montefiore, over the last year, and the reception has been incredibly positive. Particularly amongst the doctors, it's doctors, residents, interns that are at these. Some of them are in person; they come visit us at our office, and others we go out to them, or others are on Zoom. We literally get emails from doctors saying, hey, this parent, ACS is getting involved in this parent and they need your assistance. Or we get a client calling us, say, hey, the doctor at the ER said I should contact you guys. Or the Montefiore runs all these outpatient clinics too. The clinic right across the street from us, which includes a pediatric office practice. Hey, let's connect them with Bronx Defenders. That one's even better because they could just be like, hey, cross the street and go talk to the people over there. And that has become more than our previous high of a criminal defense referrals and old clients. It's this community outreach. It has completely turned the head on our intake stream.
It's great to hear, and I think, you know, not only is it bringing clients to you, but you're educating mandated reporters about what happens when they call a case in, which, at least what I've heard is that people don't necessarily know what happens
Correct.
after they make that call. It's just sort of in the void, and maybe they're contacted later as part of the investigation, but like maybe not even then. So
yeah, and it's a great education piece because and those who practice in Article 10, you'll be able to give like anecdotes. Mandated reporters don't always realize that they'll make a call, they'll hang up, and maybe not get involved again, or they'll get one call from an investigating CPS and then not again. And I'll tell them, yeah, but you know what ends up on the petition? It's like 2 lines taken out of context that might not even be the conclusion you made, but they pulled that out. That's what they extracted and put in the petition. You, as a mandated reporter, not only do you have to report, but you need to follow up to make sure that what you've reported is being accurately represented. And if any further developments happen with this family, with this child, this patient, this student, follow up with that CPS that called you, because you don't want them to get the wrong idea. I'm not asking any of you to make subjective things. Objectively, as a provider, you should give this update. Oh, I know I called this in, there was this injury. Since then, the parents have been bedside for the last 48 hours. They've been asking questions about the treatment of their child. They have, signed off on the appropriate treatments, all that kind of stuff. And it generally is, the reaction is appalled when medical providers hear just how the system unfolds for a parent. When we go through the path of a case and how quickly in that 15-month, asphyxiative timeline, it can get to something like termination of parental rights, they jaws drop. And I think it's important for that community to understand the system.
Absolutely. All right.
We have some agencies in Rochester, community agencies that are actively working around the issue of mandated reporting. And so we're trying to connect with them as well, along the lines of what George said, because a lot of reporters don't realize the consequences, and they don't realize that they can also refer the parent to someone like us while they're making that call, if they feel that that's their duty, but they can still provide the parent with an outlet to get some representation, and that's what we're here for.
Absolutely. Yep. I think Jean said it. We're not stopping you from making the call, but also make this other call maybe, or give this other information. Before we move on to our next question, I'm going to share our first CLE code for the day. And that is 8. Can everyone see my screen? I'm sharing it. It is the number 8. First CLE code is up on the screen for everyone watching, and it is 8. 3, 2, 1. All right, taking it down. All right. So moving on to the next question, and for this one, I'm gonna come back to Tonisha because you touched on this in what you were talking about before, and I'd love to hear more about this. And the question is whether you, when you get a case, if you have sort of a goal for that client, for that case. And I know every case is different, but if you can say, like, kind of in general, I'm getting a client, these are my goals for that person. And I guess hand in hand with that, if you have an overall approach to these cases, which I think is something you were talking a little bit about before, but would love to hear you expand on that.
Sure. I just like to ask the client, what is it that they need from me in the moment? Again, no one ever wakes up and say, oh, I'm going to abuse my kid or neglect my kid. There usually is a multitude of other things at play, whether it's mental health, whether it's lack of stable housing, maybe it's, food shortage, whatever the case may be. I literally try to approach it from what is it that you need? And then anything regarding the investigation, I kind of do that separately, meaning that I want you to be cooperative as you need to be, but make sure your rights are protected and you're not oversharing. I feel as if sometimes a lot of our parents, they're just so nervous or they're just so used to dealing with the system. They just share and tell whatever it is that they're going on. And a lot of times with these reports that are being made, we have to be protective of our clients' rights, not saying, I don't want you to tell the truth, but I don't need you to tell everything that's going on. I just, the investigator has, specific questions they need to ask in relation to whatever that report is about. I like to tell my parents, just answer the question. So if it's a yes or no question, just answer a yes or no question. Don't volunteer information, because sometimes when our parents are volunteering information, that can trigger something else with the investigator, and that can lead to other type of questioning and just taking in a direction that it doesn't need to go in. But like I said, a lot of times it's just needing support. They need help. I have clients who are English is not their first language, so it may be a neglect case, but mom doesn't understand. So it's really working with her, connecting her with services so she's able to send her kid off to school. Or it may be a situation where the child has significant mental health issues and they're just not able physically to go to school. The mere sight of seeing other students can set off a layer of anxiety and depression. And how do we resolve that? Okay, well, going to school physically is not an option. And like I said, a lot of our parents, they just need support. They really do. They need support. A lot of them don't know how to ask for support. So by the time a report is being made against them, things have just spiraled out of control. So I really like to say, okay, we have 60 days, right? We like to get in. Hopefully we can be, closed and unfounded. And then I'll utilize community resources that's not affiliated with CPS so they can always have their own go-to if they need assistance in the future.
Great. Robert, did you want to add to that at all? Wondering if your goals are any different than what Tonisha's are. Oh, you're still muted.
Yeah, we obviously have the shared goal of preventing any court action and ideally resolving the matter with an unfounded instead of indicated, so that there's not another mark on their record. But again, this is very social work and parent advocate intensive work. And so we try and support our social workers. We try to be a support to them as they support the parents, because it's very intense work. And especially when we get a flurry of referrals over a period of time, then they're really out in the field, all day, every day, just trying to support the parents, figure out what they need and what referrals need to be made and what resources can be tapped. And again, we try and support them as much as we can in that regard.
All right, great. And then, Jean, if you want to take the same question, if you've got sort of what you think of as a goal for your client when that person comes in the door.
I think our goal is similar to like Tonisha's and Roberts, right? Ultimately, unfounded, unfiled case is always the goal. But I think, and George and I were speaking about this earlier, but it's like our goals change with what the client may be, or it depends on the posture of a case, right? Sometimes it's a case that we're working on, and we know we're not going to be able to avoid a filing, right? So it's like, how can we reduce as much harm as possible? Right, where it's like helping the person identify a family member, right, and then making all those efforts to get a family member cleared so that the child is not going into stranger foster care, right, or like figuring out like what services the client may want or need, right. So I think it's just like trying to reduce the harm if we cannot avoid a filing, right, and then always just taking like a client-centered approach of like what it is that they want, right, like we just are there to inform them of what their rights are and what their responsibilities are, and then like how their decisions can impact them. But we're never making decisions for clients. And it's just like, this is what you want. This is how we can get there. And right, like if we're not going to avoid a filing, then this is how we can reduce the harm that you or your family may experience.
Yeah, and I'd add, so like Dean said, we were talking about this earlier, and it's funny because it is so true. The most objective, easy way to talk about what goals are in pre-petition early defense advocacy is unfounded case, no filing. But really, the three themes Gene mentioned: client-centered, reduce harm, and then for me, especially for the lawyers on our team, how I talk to them about is early defense pre-petition work is different than your Article 10 because there are no court orders, right? It's almost easy. And it's like, oh, the judge ordered this, so you have to do this. Or the judge ordered this, we don't agree, so we have to go file a motion. But pre-petition, there's no judge orders order. There's no bright line, this is what you have to do or what you can't do. So what our goal is, and this goes right in hand with being client-centered and reducing harm, is educating the client, informing them of what their options are, giving them a little bit of that, pros and cons analysis of the situation so that they can make an informed decision. I mean, the way Tonisha described like what it's like for parents who reach out to us is so accurate. It's like, it's very terrifying. So if we can help them make an informed decision about what their next move is, that's all that matters. Secret, if you do those three things, you're probably going to see a reduction in cases being filed and a reduction in indicated cases. But in the end of the day, as amazing and wonderful as those metrics are, and we love to brag about how when we do get involved, there are fewer filings and there are fewer indicated cases. But in the end of the day, if we have walked out of there having let this client make informed decisions, it's way better for the client. That one more important note, and again, I think about all the practitioners upstate who want to implement this or just starting to implement this, and it can sound a little scary too. It's like, oh, this is very different. It's not the same as what we do in Article 10. But what I'd say is you all already know how to give the kind of advice we give in pre-petition advocacy. You know what CPS, how they judge parents. You know what they take out of context. You know what they're looking. You know what boxes they're looking to check to either decide that you're complying with them or whether to file or not, or whether they think there's imminent risk or not. So that's kind of the advice. You're using that pre-existing knowledge to advise them. And then the other thing is not to beat yourselves up over whether a case gets filed or not. They're going to get filed sometimes. It's going to get filed. But even if it gets filed, if we've reduced the harm, if we haven't let the client, like Tonisha said, they didn't answer all those questions. Yes, I will do 2 drug tests for you, but no, you can't come to my house for the 10th time. I've already shown you that. Or yes, I will share that, but I'm not talking to you about mental health history when there's helping them navigate that so that if and when a case does get filed, that attorney representing them on Article 10, whether it's from your office or they get assigned someone in court, they're in a much better position. And that client is in a much better position to have a successful 1027, 1028, or you've at that point convinced ACS, yes, they're going to file, but they're going to ask for court-ordered supervision and not a removal. So there's a lot of different definitions of success. I know public defenders love to redefine success, but there really are a lot of definitions of success with early defense, with pre-petition advocacy.
Great. Yeah, I was going to say, I think this sounds a lot like, what you're maybe doing in court, right? I mean, you're explaining what the court order says, but ultimately it's the client's decision whether they're going to do those things or not. So I think maybe it's a little less defined what your client should or shouldn't do, but ultimately at the end of the day, it's sort of the same type of client counseling. So George, I'll stay with you, and I'm hoping you could talk about, and Jean, also feel free to jump in your practice. You've been doing this for a little while, some lessons learned, I think. So if you could talk about maybe something that has gone well over the course of developing your practice, and then maybe something that hasn't gone as well as you would have liked.
Sure. I mean, I'll stick with some of the theme that we've been talking about, but what works well is taking a pause and gathering as much information as possible from the client. And the reason I say that is that seems like a no-brainer, but guess what? ACS is not doing it, or CPS is not doing that. Those of us who've practiced in family court, those of us who've seen these cases, CPS is not exactly known for doing the most thorough investigations. They'll often cherry pick a couple pieces of information, run to court with it, and file something. But if you have sat down and talked to your client and gathered all the information, done the work that honestly CPS should have done in the first place. Oh, so who are the pediatricians you see? Okay, who are the people you connect with at their school? Oh, is there a parent coordinator? Not just the guidance counselor or the classroom teacher. Is there a parent coordinator you talk with all the time? Oh, great. Let's connect with them. Let's call them. Let's ask them how things are going. Let's get that documentation, because ACS won't often get the documentation that helps address the concerns they have. Gathering that information and teaching our advocates to just sit and really kind of get to know the client is really important. Another thing that works well, and again goes hand in hand with that, is if CPS decides to hold a child safety conference, we attend with them. We advise them on it. To be honest, there are even cases where we advise them not to participate because we know that all they're doing is information gathering and their mind has been made up. There's a lot of factors that go into that. And some of it also might include if they have like an open criminal case and their criminal lawyer's like, no, stay away. Don't talk about anything. We don't want to talk about this. So that has worked well. When thinking about what has not worked well, one of the things that we thought about and brainstormed too is like, what were some of the struggles early on when we were a much smaller practice? So number one that didn't work well is not being staffed enough early on. This can very quickly become a large, amount of work, especially once the word gets out. People will be contacting you. So the good news is, hang in there and keep reporting those numbers so that places like ILS and in our case, city council, other places, you can argue, hey, we need this funded. We need to be able to hire more staff. I kind of alluded to this, but what didn't work well is sometimes if we're too afraid of there's a case being filed. You don't want to become like Robert said. You don't want to become just another preventive agency, another agency that's kind of doing what ACS. Well, it's okay to tell client like we don't have to do everything ACS is asking for. It's okay if they file because we've got all our ducks in a row. You're going to be okay. We're here with you. And then that next step is what's really important. Again, it doesn't have to be the same office as yours, but if your investigation advocacy pre-petition early defense team realizes a case is getting filed, making sure you communicate with the lawyer who does get assigned to that person, whether it's from within your office or without. Even in our office, where it was the same office, where it didn't work great is if we weren't making sure we communicated. So very quickly, we learned that making sure all the notes that the advocate had from the investigation is passed along to that intake attorney, especially if they participated in a child safety conference. Giving the heads up that the case is getting filed. Also, this helps with conflict issues because early on, we might have an advocate out on the phone with somebody who called us, and meanwhile in family court, they're filing the case and our team in court is picking up the other parent. So it's like you want to just make sure you're communicating if you have an office that's picking up Article 10 cases. And then the other thing that didn't work well at first, and it's always an on and off again struggle, is ACS not cooperating or talking to us. That's hard. It's taken a lot of time, and I know we might talk about a little bit more about this later too, so I don't want to go into it too much. But it was a lot of relationship building, but also some kind of pressure from the top of like you need to tell your caseworkers that if there's a parent advocate or a social worker calling on behalf of a parent, you have to communicate with them. And it even resulted many years ago, this is a long time ago now in New York, that ACS has its own policy that they must communicate with advocates working with parents, and that was hard, but the cool flip to that is ACS kind of has realized over the years that it's good to have us on these cases because these cases can get difficult. Tonisha very accurately described how parents do not want to talk to ACS or CPS, or maybe they want to talk too much, but a lot of times they're too hesitant to talk to ACS and they don't want to share information. And a lot of times our advocates are the ones who are like, well, actually, let's share this with them so they can, understand that they don't have to be worried about this concern. And I've heard it from the top. I've heard it from the head attorney for ACS in the Bronx, who says that she actually is glad when she sees a case where our early defense team was involved, because she knows they're going to have a better picture of what's going on. And that means that the client has somebody they can trust to talk to, and then with that person, our team, can kind of be the filter that provides the information to ACS to hopefully mitigate their concerns, mitigate whatever harm they see without completely trampling on our client's privacy.
Right.
I would just add one thing that also works well is like, and this is for mainly for like the attorneys on the call, on the Zoom, is like loop in your parent advocates and social workers immediately on these cases, right? And then like let us be the bad guys, right? Because like one advice that we give our clients is like, I'm willing to do this, but before I do this, I just need to speak to my parent advocate, or so like I need to speak to my attorney. But if you have any questions, you can call my parent advocate or social worker, right? And then it's like ACS calls us. It's like, hey, we need your client to take a drug test. And like I'm the one saying no, right? Not client. So it comes off better where it's like client is saying that they're willing to comply, but they're just listening to the advice of their lawyers, right? And then it's like, well, their lawyer advised them to not take this drug test, so we're not consenting to it at this time, which is different from then the way that they'll frame that in court is like this client is uncooperative or uncompliant. And like when they use those words in court is different than if George were to go to court and it's like, well, we advise the client not to take this drug test because it's within their legal rights. So it's like I'm often being the bad guy for my client, right? Where it's like the client is willing to engage, but I told them no, right? And I think like when we're operating with and with the under the advice of the lawyer, it makes like the world of a difference, because it's like, no, like these are your legal rights. You don't have to do these things. And now we have more of a like to stand on where client is cooperating, I'm not cooperating, and then they can be mad at me, but as long as they're not taking that out on our client, or I'm the buffer between the client and the ACS worker, like I'll endure all that harm so that the client doesn't have to experience it.
Completely agree. Everybody loves to blame the lawyers, but we're happy to take that on. So Robert, I'll turn to you and ask the same questions. You know, I know you're a little earlier on in the process, but just from your perspective now, something that has worked well so far and maybe something that's not worked so well.
Yeah, I think what's worked well is just the communication amongst and between the team. We all get along really well. We all have the same goals. We sit in close proximity to one another, so we don't even always have to pick up the phone. We could just pop into someone's office or someone's work area. So I think our functioning has been very effective because of our communication, because we all share the same mission, and because, you know, we're dedicated to what we do. And, you know, most of us are from this community. Most of us grew up in Monroe County. We're very familiar, especially our social workers. They have so many contacts throughout the community. So that's really been very, very helpful. I think some of the biggest issues remain communication with Child Protective Services. They did set forth a communication protocol memo in terms of how they're supposed to communicate with us, what we can communicate about, but they often don't honor that. And sometimes they're just non-responsive. When the social workers are reaching out trying to get information on a recent referral, even if the referral came from them, sometimes they're not very responsive, and a lot of them are not being trained. They have a lot of turnover amongst our local child protective agency, so lots of new caseworkers are coming on board, but they're not being trained sufficiently about our program. So they're either not making referrals, or when they do, we find the referrals are incomplete. So then our paralegal has to follow up repeatedly just to get further information. We have our own referral form. It's fairly detailed. So if they fill it out correctly, we'll have sufficient information to get started, but hasn't always been the case. But I think communication is an issue. And in terms of what Jean was saying about thoroughness, and like Tanisha and I were talking about a case earlier, a 17-year-old mother, and the lack of delving into her life and her circumstances by the caseworkers is abysmal. And, you know, Tanisha said she learned more about her in 10 minutes than probably the caseworkers did in the whole weeks and months they've been investigating it. This is an in-court case, but it's still the same theory in operation.
Well, I think maybe that's our segue into I think the topic that maybe everybody wants to touch on, which is, what's your relationship like with CPS or ACS, and has it always been that way? And kind of what would you like to see change? So maybe for this one, I'll go back to George and Jean, just because you've had kind of a longer history with working with ACS and trying to get those things in place. For the participants, I'll let you know that communication protocol, the ACS communication protocol that George mentioned, is in your materials if you'd like to see it. We don't have the Monroe County one. I'm not sure, Robert, if that's something that you have, if people are curious about it, but the ACS one is in your materials. So I don't know, maybe Jean, if you want to start us off with sort of how things are with ACS at this point, and if you've seen a change in that regard since you've been doing this work.
I think things have changed, and I don't know if the change has been good or bad, but I think that they know who we are, they know our roles, and they know our job, right? And whether it's like you may agree with us or not agree with us, but at the end of the day, like when we're in these spaces, right, like there's a level of like respect that we demand for our clients, and like our clients are being treated with those, right? And it's just as simple as like, instead of calling our clients mom or dad, they're calling them by their first or last name, right? Like, so I think like our relationships, like, do they still avoid our phone calls? Yes, right? Like, are they always professional and like want to divulge or like work with us? No. But I think that like they understand who we are, what our jobs are, and like we know that like if we need to elevate and get a supervisor involved, we will do that, right? Because our goal is to like best support this client, right? And it's like if the worker is not being the most professional, or there's a breakdown in communication between the client and the worker, then I think like they know the next steps that we're going to take. So, and I'm not sure if that like really answers the question, but I think like we have a working relationship with them, right? Where it's like they know that they have to give out our flyers. They know that they know that they have to invite us and let us in to these child safety conferences where we had to like really make a big push for that, right? So there's been ways that we've been progressive and like gotten like knocked down a lot of like their doors or their walls to like force ourselves in these spaces. But again, I think it goes back to like what Tonisha was stating, where it's like we've built the relationship with our clients. So like even if like they're not willing to work with us, our clients are saying, well, like I'm not going to speak to you if my parent advocate or social worker is not here with me, right? I want my parent advocate and social worker in this meeting with me. So until they're here, like I am not going to proceed. So like those are the ways that we've been able to like, one, either like force our way into these spaces, and then two, get the respect that we need with our clients, so that like we can have a working relationship with ACS. And then it's like through the years of like, sometimes we're able to retain social workers and advocates long term. So like these workers know how we work, and like the benefit of having us on a case where it's like clients are telling us information, they know that we're making adequate and appropriate referrals for our clients. So like they'll often defer to us and like know that when we're on a case, like things are going to get done in a meaningful way.
One of my favorite things to see is when ACS says something like, "Oh, and the parent did this," or they're participating in this referral, and me knowing, yeah, you didn't do that, Jean did that. Like, and I'm like, I know they're taking like the credit for it. I don't care if we have guided them to where it helps our and protects our client and it serves their interests, then we've definitely made some strides. And certainly, like thinking about where this was 10, 15 years ago versus now, they wouldn't have given us the time of day. And now they're sitting here and they're understanding that we mean business, but we also like there's credibility. And I agree that there's been a lot of positive change for the most part. And we've cited some of the concrete examples, the communication policy with ACS, the flyers that they hand out with their information. But then also high ups in Child Protective and ACS, the commissioner, the deputy commissioners, even the person like the head of the legal departments, they'll often speak a much bigger talk than the caseworkers actually do. Like they get it on the big picture that we're important, that it's really important for parents to have advocates at their side, even at this early stage. One thing not to get twisted though, or misconceived, is we will always encounter caseworkers who just don't want to talk to us. We'll always encounter caseworkers who are too busy to call us back. We'll always encounter the turnover where caseworkers just don't know what they're doing. And so it's also been an education to just understand that's always going to be a part of the practice. You're always going to have that resistance. And as long as we're staying true to what client wants and client needs, and we're uplifting their rights and their knowledge in dealing with this investigation, then kind of we're getting it done. But I think it's been huge, and I think the work that the parent advocates especially have done in talking with ACS over the years really has made a difference. And it's kind of funny because my next big project is to try and figure out, I honestly think we have convinced many caseworkers like that if they just work with our early defense team, they don't even need to file. And I really do feel like I keep seeing the same names of caseworkers filing. Gene and I have talked about that, the same caseworkers who end up being the filing caseworkers. I'm like, okay, we just need to figure out who those people are, because they just haven't gotten figured it out yet, but we're going to get them to figure it out. But it's been a world of difference to get in that early stages, communicate, participate, and advocate for the clients early on.
That's awesome. Let's see, Tonisha, I'll come over to you and ask you the same question. And I'm not to put you on the spot too much. If you don't want to talk about this is fine. But you mentioned having prior experience working at CPS. So I'm interested about your relationship with CPS, but also if there's anything different about it, since you might be dealing with some of your former colleagues.
To be honest and to be transparent, I think what I didn't realize when I was in CPS is how many of my colleagues do not really support families the way that I was trained to support families. It can really be something as giving a parent school pictures. You know, there was a case I had where the caseworker refused to give school pictures doing your application. And given the current state of our local CPS, a lot of times that's basically what I'm finding to be occurring. Simple things that they should be doing regarding reasonable efforts or just support our parents and families is not being done. Just last week, I attended a meeting and it was shared that the speech services for our client was going to end on the 18th. And we're just not finding out about this. And instead of the worker taking initiative and saying, hey, you know, we need the parents to go to the city school district. We need them to be registered so we can continue speech services. That fell on me. It fell on me. I have no problems doing that because I'll do whatever needs to be done on behalf of our clients. However, a lot of times than not, I feel as if, and I think Jean touched on it, we really do a lot of lead work for CPS, more than what they're ever will give us credit for, which is fine. But I feel as if when it comes to the attorney only meetings that happen that we're not privy to, I feel as if at some point it needs to say, you know what? Maybe we could be more collaborative. Maybe it doesn't always have to be so adversarial. Maybe it doesn't have to be a us versus them. Because from our perspective, as me as a social worker, it's not a us versus them. I'm here to support my families. So if my family says, hey, Tonisha, you know, CPS is scheduling a visit for me from 4 to 5.
froze again.
Oh, I'm sorry. Oh, our Wi-Fi is so janky. I'm so sorry. What part was cut off? Sorry.
For the
Um,
last
from
30
4 to
seconds,
5?
maybe.
Yeah.
I'm sorry, I didn't hear you, Carolyn.
Oh, that's okay. We heard they're scheduling their visit from 4 to 5, and I'm guessing the
Yes,
next thing
so-
was they're at work or
Yes, so,
they
you
can't
know,
come.
scheduling, exactly. Just something that's simple, include our parents to be part of the conversation. Stop making decisions for them that's going to impact them, right? So if a visit has to be scheduled at a certain time, basic casework 100, I should talk to the parent. What's your availability? What time do you get off work? If they don't have a car, that means they're either going to take an Uber, or if they're taking public transportation, do they have enough time to get from work, to get to the transit center, to then transfer to a bus all the way out to East Henrietta Road? No one's thinking the logistics of anything. I feel like sometimes it's very black and white with them, and they do not operate with the gray. And I know from my previous experience, there's a lot of flexibility. There's a lot of flexibility. If the worker really wants to be of helping the parents to, whether that's reunification, whether that's closing the case out, there's a lot more that they can do. I feel like with investigators, it's black and white with them. There's no social work involved. Their focus is, I'm going to get in, I'm going to answer these questions, I want to do my collateral contacts, and I want to close this case. But we're going to ignore the fact that this mom has been homeless for the last over here, some kids are living over there. Of course, their attendance is going to be impacted, right? But instead of the investigator saying, you know what? Can we refer them to this particular housing program, and then maybe looking for asking mom to apply for temporary assistance, or maybe she's sanctioned. Well, how long is the sanction for? Why is she sanctioned? Does she have Social Security benefits? There's so many different nuances that the investigator have in the initial that they really could do, but they're just so focused on the referral and investigation part, they forget the humanity in dealing with our parents. Again, it's a lot to deal with. You have some of these teenagers that themselves are suffering from mental health issues. Some of our children have, developmental disabilities. A lot of our parents don't even understand that. It's foreign to them. They don't understand what it means to have a child that's autistic. They hear the term, but from a developmental cognitive perspective, they just say, oh, well, my kid's kind of slow and they don't talk. No, it's deeper than that. So for me, being with the public defender's office, my optics has definitely changed a lot, and it's more of there could be a huge collaborative effort if everyone focused on meeting the immediate needs of the family in a way that the parents can feel empowered. And making decisions regarding their children, and not have to feel so defensive all the time, or they're a bad parent, or they're a bad. I'm sorry, did my computer freeze again?
A little bit, yeah. I wonder, and if you're far away from Robert, but I wonder if it might make sense for you to go and sit next to him. I don't want to make you run across the whole office, but Robert's connection
No,
seems to
he's
be
not
working.
far.
So,
Yeah.
so up to you if you want to, but yeah, it's been a little glitchy. And Robert, anything you wanted to add about your office's relationship with CPS?
Yeah, so since the bulk of our work remains the in-court Article 10's filings, that's where a lot of the conflict arises. Now that our social workers come to court with essentially equal status to caseworkers, they've had to deal with that. They say early on, they would say things, hey, this is supposed to be collaborative. Well, once it's in court, it's adversarial on behalf of the client. So that's been something that they've had to process. I think it's gotten a little better in understanding the in-court aspects of it. In terms of the pre-petition side, again, it's really just responsiveness or lack thereof, as well as thoroughness that we see lacking. Those are the main concerns that we have in terms of what's lacking at their end.
All right. So switching to what I hope is maybe a more positive note. I think that both of you, or both teams work in areas where there are multiple family defense providers. And so we were hoping you could just talk a little bit about what your relationship is like with those providers, especially when you discover that you have a conflict on an investigation representation case. So we'll, I think we may have lost Robert and Tonisha.
Oh, we're here.
Oh, you're there. Okay, just your camera.
Just trying
Okay.
to unblur so that we could see Tanisha
Oh, yeah.
as well.
No
I'll work
problem.
on that.
All right. Well, we'll start with George and Jean while you guys get settled. Thanks for moving and being flexible. And George, maybe if you want to take this one to begin.
Yeah, so I mean, we're lucky enough that we have multiple providers here in the city, as we alluded to, that like each borough basically, and some even have two. So if we have a working relationship with our other organizations. So if we have a conflict, we'll refer to somebody who's in Manhattan or Brooklyn. It's even easier in the pre-petition phase. Obviously, you know, if it's a case that's being filed in court, that's a little more tricky. It's who the court assigns in each particular borough. I know this might be obvious for some. Each borough is a different county in New York City, so each borough has its own family court. But for pre-petition, for investigation phase and the advocacy, you're not getting assigned by the court, so we're able to do it, and then other offices will reach out to us, and we'll ask for help, and we'll do that again, assuming there's no conflict on our end. Obviously, if a case ends up getting filed in a borough that our office doesn't represent Article 10 cases on, then or vice versa, then you know, we kind of do the handoff to whichever lawyer is assigned to represent. But it is very much, we collaborate, we refer to each other pretty frequently, several times a week. We'll be sending emails back and forth.
So just to be clear, you would potentially work with someone on an investigation case who doesn't live in the Bronx.
Correct. Absolutely.
Okay.
Yep.
And then just hand that case off if it goes to court.
If it gets filed, yeah. And then interestingly, the other way, it doesn't even work. It doesn't have to work that way because over the last few years, the conflict provider here in the Bronx has expanded. It used to only be us and the 18B panel, but now both Center for Family Representation and Neighborhood Defender Services, both of them are largely based out of Manhattan, although CFR operates in other boroughs as well. They are conflict providers here in the Bronx. So if we have a conflict and have to refer a Bronx investigation to one of their offices and it gets filed, they can actually still represent. But we continue to only operate in terms of family court cases here in the Bronx.
Got it. All right. And then how about you all, Robert and Tanisha?
Yeah, so the Conflict Defenders Office, they have an ILS grant. In fact, they got a supplemental one to add more staffing to beef up their early defense work. But the public defender is the starting point for all eligibilities, either pre-petition or in court. Our paralegal staff that handles the eligibility screens everything, does the conflict checks. So for pre-petition cases, if we have a conflict, we refer it to the Conflict Defenders Office. If they have a conflict, they'll refer it to the assigned counsel program, the 18B panel. So that's been working pretty smoothly.
Have you had a situation ever, and this could be for either of you, where it's multiple parents in one family who are being investigated and they both contact you? How do you decide in that circumstance who to represent, or do you represent both? And Robert, why don't we stay with you since you?
I had one case where I ended up representing both people, and then they both got filed against, and then we had the conflict out of both. So that's always the tricky part. But generally, if we have multiple adults under investigation, we'll choose one. It could be someone, someone we've represented before, then we'll choose them most likely. If we represented multiple people, we may have to conflict out of all, but we try and find a way to represent someone at least, because we have the most resources presently to do this pre-petition work. Like I said, Conflict Defender is going to be able to beef up their staff with additional funding. The 18B panel is sort of hit and miss. I know that there are provisions for 18B attorneys to get per diem social work assistance. I'm not sure how much that's being utilized. I know that's a goal for our administrator, Mark Funk. So between Public Defender, Conflict Defender, 18B panel, we should have everything covered and be able to move forward and help people.
And how about you, George and Jean? Similar, you would, if
Yeah,
someone,
and luckily that same process of referring to the other boroughs we can do if two parents are being investigated, one we can send one to the other. We'll always just try and we'll only counsel one of them. I mean, Robert hit on some of the factors. A lot of times one of them is a prior client. Other factors are maybe they already have an open criminal case, so we see there's a good chance our criminal practice actually picked up the criminal case. And then other times, you just kind of have to pick one, which is hard. Sometimes it's just which is the parent that called us and we started talking to. Sometimes we'll get a parent calling and we'll start discussing just the very initial without getting into counseling or too much. And as soon as we realize like, oh, this is actually against the father and the mother is calling and the mother's like, he needs help. I'm like, okay, well, we're going to stop talking to you right now. Don't tell me anything else. Let's get him on the phone because it sounds like he's getting the lawyer. And then, if it's otherwise it's kind of can be a guessing game and you just kind of pick one factor. This is really more about Article 10 cases than pre-petition, but if it's against both and we're worried about a removal and one is a parent and one is like a PLR, we'll often pick the parent because they have more rights to lose. Like, God forbid this is a removal and it goes down the road, then that parent's going to also need a lawyer for TPR. Like, well, we're hopefully not. But so like they have the more rights to lose. And so maybe we kind of think about that sometimes, but it can be kind of a crapshoot. So you kind of have to take a guess.
yeah, that makes sense. All right, before we do our next question, I'm going to put up our second CLE code. And it is 2. Number 2, second code, number 2. Leave that up for one more second. Everybody have the code 2. Okay. All right.
Carolyn, also just letting you know, there are a couple of questions in the chat. I know that you have your questions, but there are some there too.
Yes, I know I feel like we could talk about this all afternoon.
I think so. It's fascinating. Thank you.
So I think maybe I'll do one more question from our list and then we'll get to the audience if that's all right. And so I think the question we'll wrap up with if I am a lawyer or I'm another professional member of a defense team, maybe a legal assistant, parent advocate, social worker, and I get that call from someone who says, CPS is at my door. What do I do? What would be your number one piece of advice for me getting that call? If you can boil it down to one. So Jean, I'm going to start with you.
So if a client were to call me and it's like CPS is at my door, I'm going to say, hold on, give me a second and call one of our early defense attorneys so that we're all having a joint conference call just to figure out like what's going to be the next steps, right? Try to gather as much information as possible without like divulging much in front of the CPS worker and have the attorney advised. And then once the attorney hangs up once like we're ready to talk to CPS, our attorney will hang up and then kind of just advise them through it, right? Like more often than not, they're just going through their checklist, right? Where it's like they're asking for a mental health evaluation or asking client to divulge if they have like any mental health history, right? I'm jumping in and it's like, well, she's been advised by her attorney not to talk about that, but is there a need, right? What are the allegations that would require a mental health evaluation, right? Oh, well, we need a drug test. Okay, like, do you see any drug paraphernalia in the home? Does the client appear under the influence of any substance at this time? Like, what is your basis for this drug test, right? there's sometimes they're asking for clients to sign a blank HIPAA form, right? And I'm reminding them like your investigation lasts 60 days. We're not going to sign that right now because they haven't had a chance to speak to their attorney about it. But at your next home visit, we'll have that signed, obviously limited in certain ways, or figure out what exact information it is that they want from this HIPAA form, right? If not, it's like, okay, well, we'll reach out to the doctor from now until your home visit in 2 weeks and get a letter from their medical provider stating whatever medical information it is that the CPS worker is trying to gather, right? But then I would like be there with the client on the phone saying like, okay, like show them the fridge, right? Do you have adequate food? Right. And if the answer is no, then it's like, okay, while we're there, it's like, hey, CPS, can you help this family with food? Can you connect them to a pantry? Right. Like putting the onus on them to provide the family with resources, right? If there's a concern about not having window guards or a smoke detector, hey, CPS, like you have a $1 billion budget, right? Like, can you buy them a smoke detector? Can you help them install window guards, right? Like immediately addressing the concerns, but also asking questions like, is this imminent risk, right? Like, is a removal going to happen right now? Like, what can we do? How can we safety plan to ensure that this family can remain together while we figure it out? Because again, it's very early in the investigation. So we just want to make sure that we're like gathering as much information in real time with the client, with the CPS worker, so that client's not being like blindsided or railroaded, right? And it's like we're doing all of this on speakerphone, so client is hearing me, right? And I think like that's what helps build like the initial trust, because they see how hard we're going for them and making sure that they're protected, right? And then it's like, okay, like now I trust you. So now it's like, okay, then client will start divulging information. We'll start making referrals, start connecting them with all the resources that they may want or need. But I would just be like, okay, like reminding the CPS worker, like this investigation is 60 days. We have time. Like unless there's something that is imminent right now, then these things can wait.
Yeah.
And just buying client time. Or it's like, you need a drug test before we consent to that. We just want to speak to her attorney. But again, are there any concerns for drug use other than this report?
Yeah.
Right.
And what
You
I'm
want a
hearing you
mental health-
say is just slow it down.
Right.
Slow it down. Yep. That makes sense. And then Tonisha, I'll turn to you if I'm getting that call and I say, Tonisha, what do I tell my client? What would you tell me?
The first thing that I do, I call the attorney. Similar to Jean, we've actually had that happen. It really was a situation with law enforcement and a warrant, and I'm on the phone with the client in one ear, I'm on the phone with the attorney in another. It's really just making sure that their rights are being protected. I feel like that's the most important part of all of it. As I said earlier, clients are already defensive. They're already nervous. They're already a nervous wreck. So for CPS to show up with law enforcement, it definitely escalate things a lot. From an emotional perspective, people are nervous, they're upset, they're anxious, they're crying. It's a lot of things. I just try to just let's control this as best as we can. Can I talk to the worker? Sometimes it's somebody that I'm familiar with. Hey, what's going on? Okay, can you tell me why you're at the home today? Okay, there's a report made alleging X, Y, and Z. Okay, can I speak back to my client? Client, I need you to close the door. I need you to talk to your attorney. We've really tried to connect in a way that we try to jump ahead of the situation if possible, but also, again, protecting our clients and their rights to making sure that they're asking whatever the investigation questions may be, that they're only answering what's being asked of them, nothing more and nothing less. And I wholeheartedly agree with Gene. I think he said it earlier, just because CPS asks for it doesn't mean they have to get it. And I feel a lot of times they're not, because they're CPS, they have this undominated power, right? They could go into schools and interview kids whenever they want to. They can go into homes. They can go in the bedrooms. They can have this unfiltered access, and no one ever tells them, no, sorry, I'm not agreeing to this unless I talk to my attorney. I'm not signing this release unless reviewed by my attorney. No, you cannot see my bedroom because my social worker says you're only supposed to see the sleeping arrangements for my children, right? Like there's unfiltered access that they have. And I feel as if a lot of times or not, our clients, without our involvement, they just go along with it. They're scared, they're nervous, not realizing you have powers too. You have rights as well, you know. So I think it's just very important for us as a social worker, the parent advocate, that as soon as we get that call, I'm on a three-way call with the attorney and saying, hey, this is what's going on. What is the best way to proceed? Sometimes that may mean us being on the phone the whole time. Sometimes that may mean, you know what, I'm on my way right now. Tell them I'm coming, and then we'll just take it from there.
Mhm. Advocate for your client.
And I just want to add like one thing, and I know it's like separate and apart from the question, but it's like one thing that's important is that we're also not ignoring whatever concerns ACS has because they might be true or not, right? Our goal is to protect the family while also connecting them to resources. So client might divulge like, listen, like I might be struggling with like substance misuse. And it's like, okay, are you ready to go into a program and can we connect you with the program? And if client's saying yes, then that's when we'll make those referrals. So I don't want it to sound like we're just telling ACS no, 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 right? It's like, no, like let's help this family in a meaningful way that is not punitive and not punishing them for things that's happening throughout the course of life,
Yeah.
right? Like
Yeah.
we're addressing the concerns, but in a way that's going to be helpful to the client and not involve family separation or being punitive in any way.
Absolutely. Well, thank you all so much. I think we're 1 minute over. I did want to try to take some audience questions if we can, if people are available and we're able to stay on.
I can just jump in real quick. I saw that one of the questions was somebody said if we have slides that we use for mandated reporters, and I'm happy. I'll pull together some slides that we like, including like just something as simple as path of a case and stuff, and I can send it to you all to disseminate.
That would be great.
Perfect. Yeah, that would be fantastic. Thank you.
So if you can stay, we'll try to catch up with the questions. I did want to bring this one up to the top though, because I think it's important. Lisa Strand asks, how do attorneys find out if these services are available where they practice in New York? I don't know if there's like a master list. I'm not sure if Lucy's list covers this. But if it does, then if there is some kind of a list, perhaps there's something to circulate.
Yeah, the map and list cover what we're funding. If counties are doing it on our own, that's great. And that would be information that we would also want. So if you're willing to share that with us, that would be great.
Okay, so Lucy, you're going to send us your stuff. George will get stuff from you, and we'll circulate to the attendees so you have that information. For those of you that are still on, we'll go back and catch up with these questions. We have a question that Bonnie says, my impression is that parents give up in Article 10 proceedings, and is that correct?
When you say give up, you mean sort of like stop participating or, and
I don't know if
sort of
Bonnie's
stop-
still on, but if you're still on, please feel free to unmute yourself and clarify that. I mean, I would guess, just based on my experience in dealing mostly with the family court appeals, it's that they kind of maybe lose hope in the Article 10 proceedings, but I usually see them after they've been in court. So I don't know if it changes in the pre-petition stage or not.
What I'll say is, if we're interpreting this right, is that it is true. Parents can kind of get beaten down with this process, which I feel like is why getting advocacy at a pre-petition early defense investigation phase is all the more important, because you're helping try to prevent that early on trauma. Because I mean, like by the time they walk in court, I mean the trauma is, it's like we're already way down that road, and so it is easy to feel pretty helpless. And so I think that a notion of empowering, these things that we've heard from Gene and Tanisha, especially like this is what you can do, this is what you can say, is going to help empower parents to feel like they have a voice, they can be heard, they can fight what they feel is unfair, and what is unfair targeting. So I think, if anything, if there is that sense that they give up, I think having pre-petition advocacy helps with that.
And I do see that Bonnie is still on, and she does also add that she's an appellate attorney. So this is what she sees from the record, which is what I was telling you guys that I see from the record as well. Okay. George, you covered the other question about the thing that you're going to share. That was a really inarticulate way to say that, but we're going to move to the next question, which is there any advantage to not submitting to an alcohol and drug test when the allegations are drug and alcohol misuse? If there is a recommendation for an evaluation, then there will be one at the evaluation, or this fast track's going to court and ordered by the judge to go. So I think the question is there any advantage to not doing it when these are the allegations?
I mean, I would say, yeah. Again, you inform the client, you tell them, hey, this is what's happening. If you test, and sometimes these are the hard conversations you have with client. Do you know whether you would test positive, and for what? And none of us are, well, maybe some on the call are medical professionals, so we can't exactly say this with certainty. But there's a rough understanding that of how long alcohol stays in the system, how long other drugs stay in the system, and you kind of advise them on that and say. You could refuse to do that. And the advantage is, the short answer is, the advantage is, yeah, they don't have evidence against you. That's one less piece of evidence to use against the parent. What if they don't test today and in 2-3 days they do end up in front of a judge and the judge orders them, but by that point you get a negative test? I mean, let's be strategic about this. Sure, it could absolutely be good. Sure, they filed, you didn't prevent the filing, but you might have helped, a piece of evidence. And then, like Jean said, it's not like we're doing this to be like, get away with it. It's okay, let's not take the test. Let's get you in a program. Let's get you the supports you needed. Clearly, you didn't have those until this time. It doesn't necessarily mean your kids should be taken away from you. It means we should be supportive. And the other comment that was made that I saw publicly is it's not going to be an empathetic, kind, gentle approach by ACS to do this. It's going to be accusatory. So let's protect them as much as we can from giving their own evidence. And get them the support they need. So there are circumstances and times when you're like, yeah, don't go to the test. And if they file, we'll figure it out. By the time they file, we'll figure this out.
Okay, great. I think that covers it. Oh, go ahead.
Just to add a little bit to that, like, I think
Yes.
like in the early defense, what's helpful is like, yeah, ACS is asking for a drug test and we might have advised client no, but in the interim, it's like, but we already scheduled the intake appointment. So if they don't have they don't have a test on record stating whether it's positive or negative, but if you can go to court and be like, listen, like, we understand this is a concern, but client has an intake appointment for this day and time, they're ready to engage, they're going to comply with services and all of these things. I think it's a different argument than just like, client didn't take a drug test.
Right. Robert and Tonisha, do either of you have anything to add?
Yeah, so again, we're assessing at the point that question is being asked, but for this result, is a filing likely? Is an emergency removal likely to happen? If it's definitely heading in that direction, then again, like George and Jean said, don't provide them with any more evidence at that stage. And again, by the time you get to court, like Jean said, you could have some appointments lined up and then make the case, argue the imminent risk or lack thereof.
Okay, I think there's a question here. I'm not sure that I understand it, but perhaps our panelists will. It says, is the doctor's misdiagnosis like Adrian Thomas scenes of a crime common?
I'm not familiar with Adrian Thomas, but I'm certainly familiar with doctors misdiagnosing things all the time. So, I feel like there was like a Law and Order SVU episode too earlier this year about like a child abuse pediatrician who totally like bungled it and misdirected, and the cops went after her, which is like, wow, this is nice. It's refreshing. Misdiagnoses happen all the time, and it's why, and like that's part of the presentations we give to doctors, and it's part of what we also at our practice have this complex litigation unit that deals with the really tough things like fractures and bad injuries to children, and it's wild. It's shocking how much things get misdiagnosed. And also the phrase rule out intentional trauma or intentional injury. That doesn't mean that's what happened. It means that they're not sure yet. But ACS misreads that all the time. Oh, doctors thought that this might be, abuse and intentionally. No, the doctors still need to rule that out. So misdiagnoses happen. It's why, again, this greater communication, connecting with doctors, and something we do with clients who have medical investigations is we we try to get access to the medical charts for them and or their children. In New York City, I'm not sure if this is kind of everywhere in the country now. I have friends and relatives. So my charts, like online chart systems, exist now, and we get their logon, or we help them set up a logon. And sometimes we're pulling like X-ray results and things from hospital records that ACS hasn't even bothered to get. And we're like, whoa, pump the brakes. You're saying that there's this accusation, but what about this report that just came out last night, or that's in the record now as of this morning, that actually has a perfectly good explanation for XYZ? So I don't know if that's where the question was going, but
It looks like it was. Yeah, the doctor diagnosis, I guess in that case, was the child had been hit. So
yes, misdiagnoses happen all the time. ACS does an abysmal job of doing actual thorough scientific investigations when it comes to actual scientific issues. So we get in the weeds. We get all that information from the client, from their providers, because we're pretty sure bet that ACS is going to get it wrong in some way, shape, or form.
do any of our other panelists have anything to add to that? Okay, well, thank you everyone for joining us today and for staying long, for those of you who stayed to hear the answers to the questions. In the next day or so, we'll get you the additional materials that we've talked about today. And I believe, I'm not sure if I circulated all of your email addresses, but as long as it's okay with everyone, when we circulate the additional materials, we'll circulate everyone's email addresses so they can reach out to you if they have questions, correct? All right. Great. Thank you, everyone. Get your CLE codes to Lillian by next Friday.
Thanks, everyone.
Take care, everyone.